My Lords, I rise to speak to the two amendments standing in my name in this group, which are 13 and 28. In doing so, I'm conscious of speaking particularly after the noble and learned Lord Hope of Craighead, with whom I agree on the matter of principle, which is a nice, easy place for me, but disagree on the response of substance, which always fills me with trepidation to think that I'm not on the same page as he is on something. I'd like to address these two amendments in the reverse order, so to speak, speaking about 28 first, and then about 13. And I should say in relation to 28 that it should have been coupled, and this will be corrected on report if we get that far, it should have been coupled with a proposal to delete lines 36 and 38 on page 2, which it appears to replicate in some ways. But I think the substance of what we're discussing is essentially clear. The noble and learned Lord Hope of Craighead has rightly pointed out that the bill lacks a clear definition of what is meant by free speech. And on that we agree. He proposes that the definition of free speech be tied to the convention right in relation to free expression. My view is that that does not take us far enough, that the convention right is subject, first of all, it is subject to the jurisdiction of the European Court of Human Rights, which has a history of narrowing that definition over time. So creating more exceptions, for example, for the protection of reputation and so forth. And because it is, of course, one that can be appealed to the European Court of Human Rights, it is likely to be interpreted in a very legalistic way by universities and lead to a great deal of litigation. Whereas, as the noble Lord Treesman rightly said, universities need to be persuaded to own this as a project and not regard it simply as a further aspect of the legal thicket through which they have to work. There is also, I think, great advantage, my lords, in having a definition of freedom of speech, which is a British tradition and is based on British notions of common law, the notion that you are free to express anything which is not specifically prohibited by law. And that is a different approach, if I may say so, to the one being advanced by the noble and learned Lord Hope of Craighead. Amendment number 28 is an attempt to put that approach, the idea that you can say something as long as it is not prohibited by law, into the statute. So that is really the essence of 28. It does contain an exception for Holocaust denial, but otherwise I think it resolves this question of defining freedom of speech in a clear and unambiguous way. And also, I say this without knowing any more than the noble and learned Lord does about the government's current intentions in relation to the Human Rights Act, but of course my definition of freedom of speech would future-proof the bill against any attempt to resile from the European Convention on Human Rights that might come forward in that legislation if it appears. I now turn, if I may, to Clause 13, which is an attempt to define what is meant by reasonably practicable on the part of universities. And here, as the noble Lord Treesman has made clear, drawing on his own experience as an academic, there has been a significant change over the years in the attitude of universities towards these tricky and difficult questions. As he says, some years ago, perhaps when he was a younger academic, the university authorities were themselves committed to freedom of speech, and it was they who would be protecting those who wished to express controversial and difficult appointments from the sort of activist behaviour or the riots or the mobbish type behaviour that might seek to close them down. The situation now, as the noble Lord implies, that very often the problem arises not simply from the student activists, it arises more from the university authorities. So we need, perhaps, I think, a more directive approach, one that makes clear what the burden on university authorities is in protecting free speech, since we can no longer rely on that innate instinct of theirs to do so. And Clause 13, as I say, is an attempt to do this. It really requires, first of all, it makes it clear that doing nothing is a reasonable activity. So not intervening in order to close things down is a perfectly reasonable activity, and that there should be a clear obligation of tolerance on the universities, allowing them only to restrict speech that harms the functioning of the institution. Now, that is a vague phrase, and perhaps in discussion could be improved as we approach, as we come to report, but I would suggest that latter category would include antisocial behaviour of abuse, insult, or destructive behaviour, or racism. Those things could be taken to harm the functioning of the institution, but they would be narrowly drawn so that in practice the university had an obligation, a legal obligation, to defend the rights of people to their free speech. So it is, if I may say so, a different approach. It's a slightly fresh and unusual approach. We're so used, and understandably used, to relying on the European Convention as the basis of our interpretation of rights in the modern age. But of course our rights go back well before the drafting and accession to the European Convention of Human Rights. We have a proper and correct and distinct British approach to rights. The notion that one should be able to say something that is not prohibited by law and be free to do so is a much wider notion than that embodied in the European Convention. I think it is a defensible one, and I think the notion in Amendment 13 of what constitutes reasonably practicable addresses this change in circumstances since the Act of 1986 in a way that the noble Lord Treesman has identified, and I believe makes the obligation on universities, the fairly vague obligation in that Act, much clearer and much more deliverable.
My Lord, to follow the noble Lord, and I think already in this very short, but very